And that was great. So our next panel, Youngly's not here, but we have the other three panelists, Dan Hyde, Timothy Spangler, and Nicola Mcneely. So you can all come up. And the topic is going to be the legal and regulatory evolution of NFTs. What's coming and what can you do about it? You all have your own mics.
Your time. So why are we here? We're basically here to share some thoughts, some ideas, and just to moot around some ideas around what's happening with NFT, the law, and the regulatory space. So why am I here? I've had a roller coaster ride over the last 10 years. I've been a lawyer for 25 years, and I started working with the British Royal Mint back in 2013. The British Royal Mint make the money in your pocket, and they make the money for most governments around the world. And they realized pretty early on that we were moving to cashless society. And they said, right, what are we going to do? Because we're not going to have a business. So I worked for their new business division, and part of my role was to help work out, from a legal perspective, what the world would look like in a cashless position. So that moved me into stablecoins. So we worked with the Chicago Mercantile Exchange, we worked with Alpha Point, we worked with BitGo, and we built out one of the world's first stablecoins, which was a gold-backed investment token for payment and remittance. So we were basically working on behalf of the UK government to create what was a forerunner for central bank supported digital currency. So I was one of the first lawyers ever to work in that space. So I was working on stablecoins and the tangibles. And at that point, I remember going to conferences back in 2015-16 and talking to people about non-fungible tokens. No one said NFT. So people just said non-fungible tokens, and no one really understood enough about it. You know, people knew about CryptoKitties, and it was just seen as a bit of a surreal thing. But there was definitely a buzz back at the time, and what we used to say was, whoever understands and gets to grips with this NFT thing or this non-fungible token thing will be really, really rich, right? Fast forward to now, and just the revolution of NFTs over the last 4 years and what's happened during the COVID pandemic, and we are where we are in terms of non-fungibles now. The world's taken over and it's growing really rapidly. So I'm in an enviable position that I act for some wonderful businesses in Web3, infrastructure providers, exchanges, platforms, Fortune Magazine Nifty 50, influencers, so people that really change the market and do some really interesting stuff. So that's my day job. I'm a mum with a 6-year-old boy who loves buying NFTs as well, so he chooses the ones I buy. And I'm here with my colleague Dan, so I'll pass you over to Dan.
Oh, thanks, Nicola. Can you all hear me okay? Great. Okay, so yeah, Nicola and I work closely together. I'll give you a little bit of my journey as to how I got here. So I started life as a financial regulation lawyer. And rather like Nicola, I could see, horizon scanning what was coming. And it kind of struck me that lawyers in particular weren't even ready for it. We had universities that weren't training people for crypto regulation or crypto businesses. So I started trying to write, and initially nobody was interested, saying, well, why would we publish a book about crypto or blockchain? It's never going to sell, nobody knows about it. And it was I think in the UK, it was in 2017 when finally I had my books published. And then on the back of that, everybody suddenly thought, well, hang on, maybe there's something to that. So I then started speaking to universities, designing courses to try and train lawyers of the future. And that was great. And so now I teach at Cambridge University. I'm a professor of law and also of what they call cyber regulation. So effectively, I'm now training lawyers so that hopefully they can help you guys. In terms of how we can help you, I think one message I want to get out there, which I haven't heard very much today, and there's been lots of stuff about law, but I think the main problem with, or not a problem, but one of the designing features of a business, if you like, that involves NFTs is often its kind of global nature. So if you're trying to launch a successful business, most of you guys, you're not just going to launch in New York, or your target customers are going to be all over the place. They're going to be in different jurisdictions, different countries, maybe different states. And the reason that's so relevant when we're looking at regulation and its evolution is that you actually need to map who you're targeting, where they are, where most of your potential is, and then make decisions as to, how is this going to work. If you're engaging with different jurisdictions, some of them may be favorable to your business model, and some of them may not. And maybe at this point, I'll just explain a little bit about why NFTs are so hard to regulate. And I think in order to understand that, you need to understand a little bit about NFTs. So all of us in this room probably think we understand NFTs, but what are they in terms of how the law sees them? So one of the great commercial advantages of an NFT is it's chameleonic. It can be so many things. It can be a digital tag. It can actually be a computer because it can store and process information. But because it's so chameleonic, it can be used in so many different ways. It can be used standalone as art. It can be used to facilitate other things. And that makes it quite hard for the law, because don't forget, most of the law came from an analog age, not a digital age. So what happens with the law is it basically looks at what you're doing with your NFT, and this is the case for probably most countries and most jurisdictions, and it says, okay, let's look at that NFT in context and try and decide what you're trying to do with that NFT. So if you're using that NFT, as we've heard today, to be some form of security, most countries are going to have a problem. If you're using it to prop up some kind of investment scheme and you're not authorized for an investment scheme, you're going to have a problem. If it's part of some form of illegality, I don't know, if for example, it's gambling and you're marketing to customers in an Arab country like Dubai, then you're going to have a problem. So I just thought, before I passed on, I just sort of raised that point, because we've really got to have kind of a more, global, universal approach to this. And also, as I say, when you're looking at your business and maybe what your minimum viable proposition is going to be, you might actually have to make some compromises, because it might be that what you want to do won't work absolutely everywhere, so you might have to trim it down. I'm going to hand over to Tim now, who's going to speak to you from the US perspective.
Does everyone? I kind of project, so it shouldn't be a problem. My name is Tim Spangler. I started my legal career about 25 years ago in financial services. So I worked in the big towers in Midtown and downtown Manhattan, making the world safe for capitalism, largely working for hedge funds, private equity funds, and the like, but very, very deep into financial regulation. 5 years in New York, 12 years in London, and the last several years in sunny California. So all this cloud and rain is quite confusing to me. I fell down the rabbit hole in late 2016, early 2017, when I got a number of questions from something called chief compliance officers. They're a species of lawyer that lives in the big banks. And I was getting lots of questions around, well, what is Bitcoin? I don't know, but from a regulatory perspective. And it was really from there that my legal practice has pivoted over the last 6+ years, looking at digital assets very much from the point of view of the fine young men and women at the Securities and Exchange Commission, your Securities and Exchange Commission. Many of you who are in crypto for any period of time will hear about something mystical and magical called the Howie Test. And that was really when you look at a lot of the SEC public pronouncements in 2017 and 2018, they really focused on when are these digital assets securities. You might think it's a utility token, but the men and women at the SEC will tell you, no, 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 it's a security. We've gone through that over the last few years. ICOs and fungible token offerings are conducted in a very different way now than they were in the heady years of 2016 and 2017 and very early 2018, because this Howie Test, and what does the Howie Test tell us? If it's an investment of money in a common enterprise seeking to make a profit, this is going to be important for the next few minutes, by using the managerial and entrepreneurial efforts of others, you have a security. I'm here to make a suggestion to everyone in this room and really everyone in the conference. One of the most important under-discussed issues around NFTs is how collections of NFTs fall in or out of the Howie Test. Now, my young daughter does a crayon drawing on a piece of paper at a restaurant. I create an NFT of that. Is that NFT a security? No. I think the argument that my daughter's drawing that's now on the Avalanche blockchain is a security is very, very low. So my middle son takes his guitar and plays a song and records it as an MP3, puts that MP3 on a blockchain as an NFT. Is that a security? No. Okay. Let me pose to you a question. If I simultaneously launch 10,000 near identical NFTs, and they're a laughing hyena or a smiling snowman or whatever the aesthetics of them are, is the person buying that laughing hyena number 172, does he really like the color of the fez that that laughing hyena is wearing? Or, that's option one. Option two is that the laughing hyena set of NFTs was launched by a management group that included Bob and Carol and Diego. And can I tell you, Bob and Carol and Diego are superstars. They've got this whole idea for marketing this suite, these 10,000 laughing hyenas, and they're gonna get movie deals, and they're gonna get licensing deals, and they're gonna drive the price of your laughing hyena 172 to the moon. Wait a minute. That sounds like managerial and entrepreneurial efforts of others. I would draw all your attention, to the extent that you want to think about this, to a number of the pronouncements that the SEC has made over the last several years, starting with the Dow report that came out in the summer of 2017. I don't know where NFTs are on the list of SEC priorities. It will get to the top. It will get to the top eventually. Whether that's 6 months or 12 months or 18 months down the road, they will be asking a lot of really, really difficult questions around this. And what I want to close kind of this intro remark with is the following. I'm just a lawyer. It's your job to make money. It's my job to help you keep it. You might think not making money is one of the worst things in the world, but let me tell you something even worse. Making money, spending it, and now having to find a way of giving it back is by far worse. And that's the remedy for a violation of the federal security laws. So I want to turn it back over to Nicola.
Perfect. Thank you. Yeah.
I only use my moderator status when it involves Howie Test, things that I disagree with. I imagine, because what you described, that we have all Bored Apes as being securities. But from my understanding of the Howie Test, it's not just that something could go up in value or the creators want it to go up in value, because if I make a classic car and I trick it out and I trick out a dozen of them, that doesn't make it an investment contract. Now, if I go and market it and say, these are going to go up to the moon, that's a little bit different. And that's, I think, why the SEC hasn't really even addressed Bored Apes or other ones as being securities.
I would agree with 95% of what you said until the last, 11 words. If you buy a pair of Yeezys, or you buy a young girl sitting on a chair on the Champs-Elysees and you buy her oil painting, fine, you want it to go up to value. The fact that it's a collectible is interesting, but that doesn't make it a security. But when you're launching 10,000 near identical objects, and identifiable people, Bob and Carol and Diego, are telling you, I am going to market this, I'm going to drive this to the moon, I know people with Steve Aoki, I know people with Snoop, this is going to go to the moon. Then the question that the SEC will ask, as you, did you buy, Lazy Gorilla 17 because you really like the aesthetic way the color of the fez was painted in? Or did you say, Bob and Carol and Diego are superstars? They are monsters. They are going to market this to the moon. The SEC is going to say, if you picked their efforts ongoing, you've bought a security. Congratulations, you've bought a security.
Doesn't that have to be the way that it's marketed if they're saying it's security? Because otherwise, I would suggest what you just described was one of 1,000 of an artist doing a serigraph in non-digital form. The exact same things could apply.
Right, but when I buy
Snoop Dogg does a painting and does a serigraph. Anyway, I'll hand it over to the rest. I just want to raise those points.
I love the point, counterpoint that.
Thank you very much. I was just going to say that the purpose of us talking today is just to debate some of the issues and see what's coming down the line. And I think one of the scariest things, Tim was talking about making lots of money, spending lots of money, and giving it back. But what's scarier is going to prison. So, you look at what's happening with OpenSea and the employee there thought he'd make a quick buck by buying some NFTs and then flipping them because he knew they were going to make more money because they were featuring on the front page of OpenSea, and I think he made $45,000. But now he's facing a lawsuit for money laundering and criminal prosecution, could go to prison for 10 plus years. So is he a scapegoat? Yes. But do we think that there's some rules coming in terms of insider trading in NFTs? What do you think is going to happen in the space? Do you have any thoughts on that, Dan and Tim?
Yeah, just briefly. So, I mean, to my mind, we already have those rules. I mean, one of the difficulties with people, not being prosecuted for something isn't normally because the law isn't there. It's just because there isn't the appetite, or it's not low-hanging fruit. It's not a priority. So this prosecution that Nicola's mentioned regarding, I think he was head of product at OpenSea. Yeah, it's been, it's overdue. It was long coming, but in the UK, in the US, in most jurisdictions, there are ways, even if there isn't specific legislation, there are ways in which you can prosecute, whether it's insider dealing, whether it's some other form of fraud. So I think, as I said at the outset, when you're looking at NFTs, it's about context. So people often say to me, oh, crypto or NFTs, all this stuff, it's not regulated. But what you do is you look at all the other bits that are wrapped around it and say, is that regulated? Is that criminal? Is that something else? And I mean, just to take the wider piece as well, I think you have to step back because there's a lot of focus on just the NFT. But I mean, for example, if you go wider than that, what about the utility providing? What about the other things you might be offering? What rights are you giving? How are you raising money? Is all of that is all of that proper? Is all of that going to be compliant? I mean, I know I keep giving Nicola a name check a lot, but we work a lot together with ventures. So literally, we sit down and we go through stage by stage and we look at it from, ideation, what they're looking at, and then once we give them sort of regulatory sign-off, we'll then even get into, she'll draft the contracts and we'll work it all through. So, it's quite a big journey. We can't cover it all today, but as I say, what I wanted everyone to kind of understand is that when you're looking at regulation, it's not just, sure, securities are important, but you've got a whole piece. It's like, when you're advertising, when you're making a financial promotion, are you, is your financial hygiene compliant? Are you committing any other offense? It's a lot to look at. And the last thing I want to do is to put anybody off, launching a business or continuing with the business. It's, I think being entrepreneurial is fantastic. It's just you've got to understand that probably the best way of putting it is NFTs do have tripwires. So, those tripwires tend to be, in my experience, things like, is it some kind of regulated activity? So is it an investment scheme? Is it security? Is it maybe gaming? And gaming can even be, for example, where you might have some scheme where you're giving some kind of reward, or it involves some kind of, chance, but you've just got to have an overview and just sort of say, okay, is this safe? And if it isn't safe, can I kind of tweak it in such a way that it's going to, help me sleep at night because I'm not going to be going to prison? Let me hand over to Tim to pick up from there.
No, absolutely. Great points. A question I get asked a lot is, well, when is the SEC going to pass rules? When is Congress going to pass statutes? And what I like to remind people is, independent of anything new created from a legal and regulatory point of view with regard to digital assets, including NFTs, law exists. I remember a philosophy professor reminding me that God doesn't come in and out of existence based on my life, what I happen to believe at a given time. It's either they're there or they're not there. And the same thing is with the law. Just because you're not thinking about the law doesn't mean the law doesn't exist. And we've had law, common law, English common law, for 1,500 years. You mentioned the OpenSea's case, and I had a number of people in over the last year tell me, don't worry, Tim, insider trading doesn't apply to digital assets. It only applies to securities. But if you read the OpenSea indictment, they got that young man for wire fraud. Wire fraud, like RICO, how many people have watched Sopranos, covers everything. Anything that a regulator or prosecutor doesn't like is covered by that. I would say the law applies to you in every meaningful way right now. Don't let the lack of a court case or lack of a pronouncement by a regulator think, oh, somehow the law doesn't touch me. I think the next 12 months will be incredibly incredibly crucial for people in the NFT space. You were mid-2017 ICOs. Congratulations. Money is flowing around everywhere, and eventually mom and dad at the SEC are going to figure out that you're having a party, and they're going to come down and check it out. So what I encourage you to do is not wait until you're reacting to what the regulators and the prosecutors are saying. Think about jurisdictions. Think about who's buying and who's selling. And please don't tell me, don't worry, Tim, I set up a company in Mauritius. I am golden. That doesn't help either. Look at who's doing what, where are they located? Look at who they're doing it to. Who are you selling to? Who are you contracting with? Where are they? If you're in New York and your buyer is in Florida, the fact that you have a Mauritius company helps you precisely 0%. I would actually argue it harms you by using a Mauritius company because it gives you an illusion that somehow you're not subject to the law as you are. I think the next 6 to 12 months is going to be incredibly important for the NFT community because you're doing really well, you're making lots of money until the last few weeks. That means you're going up and up and up the Security and Exchange Commission's list of priorities.
So yeah, as you say, the market's been tough the last few weeks, but one of the best quotes I heard at NFT.NYC was, it's not a bear market, it's a build market. So following that strategy, I'm building at the moment, I'm reinvesting and I'm buying the stuff that I wanted to buy 6 months ago but couldn't afford, but that's not investment advice, that's personal interest. So what I'd like to advocate today is trying to create the best in class for NFTs. So I've seen some rubbish over the last couple of years. You know, you look at the Art Wars NFT drop last year by Ben Moore. He created an NFT drop, made $3 million overnight, selling 10,000 versions of the Stormtrooper helmet, the Disney Stormtrooper helmet. They had big people involved. They had Leroy from The Prodigy. There's some great influencers involved, produced some great art, dropped it on OpenSea. They hadn't secured all the licenses from their artists. The artists complained to OpenSea, the project got dropped, it got completely pulled, everyone on the secondary market lost their money, and they made $3 million and put some videos on YouTube shooting guns, running around going, we've made $3 million. That's shit. Let's not do that. That makes everyone look bad. You know, people lose money, there's harm to consumers, and that's when the SEC and the FCA and other regulators have to step in because there's bad practices. So let's do the best in class for NFTs. Let's when you're launching new projects, make sure that you're very careful and very transparent with the market about what rights you give to your founders, so what interests you have to your founders. If you're working or collaborating with anyone, make sure that they can't buy in until the secondary market. If they're going to be on the whitelist, that's okay, or the allow list, that's entirely fine, but make sure that they're on the allow list that's just the same as everyone else in the community, so they participate in the Discord in the same way. You know, it's got to be completely transparent and open, because if you don't have that, I think that's the next layer of issues that are going to come through in terms of insider trading, insider knowledge and stuff. So anyone you're working with on your projects, just be really careful of that. Make sure all your contracts with all your staff, employees, consultants, advisors, collaborators all say that they can't buy into the project, use insider knowledge. All that sort of information should be in there. It's absolutely vital, because if you lose the trust of your community and something comes out about your project, you'll lose all your credibility. And that is happening quite regularly. There's lots of projects that are having big problems. Look at what's happened with Azuki, you know. So there are issues out there, and we've got to solve those issues. So my one plea today is, as a community, let's try and do that together, and think about what you're doing and just thinking, does this feel right? So if I was buying an NFT and I found out about this afterwards, would it feel right or would it feel wrong? And that's always a good test, that scratch sniff test. So if I was a buyer and I found out about this, would I be upset? And if you would be, don't do it. Okay, any other final thoughts?
I'll be very quick, so I think we're running out of time, but just to emphasize Nicola's points, I think it's a great one. It's basically about due diligence, isn't it? It's if you're dealing with NFTs, you know, are people's expectations going to be fulfilled? Can you sell or transfer what you claim you're going to sell or transfer? You know, if it's an NFT basically used in the sale of an asset, don't conflate the two. You know, the NFT and the asset aren't necessarily the same. Can you convey what you say you can? Because again, that's what the regulator is going to look at when things come falling down. And it's basically about fulfilling expectations, doing your due diligence, making sure that it does what it says on the tin and it's going to perform. And that's probably half the battle. Tim?
Just 20 seconds. I just want to say where there's technological problems, there are technological solutions. Where there are legal problems, there are legal solutions. I'm a big believer in the space. I'm a big believer in NFTs. I'll be outside after the presentation if anyone wants to chat.
Thank you, panel.